I'd like to thank you all for coming tonight. It's kind of an interesting topic. We're going to talk about estate planning and vision planning. Oh, we're going to switch mics. Maybe that one will stay on. Our format tonight's a little bit different. This is going to be a town hall meeting, so hopefully you guys will all participate with your questions. We've gotten a few questions already from you, which we will repeat. We've got our panel here. So joining me on the far left is Nick Warsh, and then Cale Scholes, Dan McGreevy, and Nancy Williams. All of these guys, plus all the advisors in our office, are certified financial planners. And on your tables, you'll find a list of everybody on our team, so you can check out who we have, including some of the newer additions. We're now up to about 24 people. We were just talking, ironically, this room is where we did our very first seminar. 1986 was the first event we ever did. So it's been a little while. One of the things when we started our firm that was very important is to support the community. You know, our mission is to make people's lives better, our clients, our team, and our community. One of the things that we started doing several years ago was partnering with people locally, what we call our Carver Cares partner. And this evening, I'm really excited to talk just for a minute about junior achievement, because junior achievement's mission is to inspire and prepare young people for a global economy. They have a number of classroom programs, K through 12. Right now, they're in over 1,500 classrooms in Cuyahoga, Geauga, and Lake counties. In the last year, they presented to just over 22,000 students. So it's pretty amazing what their reach is. Junior Achievement's 3 pillars are career readiness, entrepreneurship, and financial literacy. And they've got about 20 different programs that focus on these things, where students learn not just financial literacy, but also skills that employers are seeking and they may not otherwise get in school. The other thing that they learn are tools for finding a job, including things like resume writing, interview skills, and just searching for a job. Junior Achievement's been around since 1941. They are run by volunteers. Currently, Kelly and Dan in our office are teaching, but we're becoming more of a partner. If you're interested in volunteering, you can learn more about them with Al DeFranco, who's over there. He'll be around afterwards. He's the Vice President of Development for Programs. And on your tables, you'll find a sheet that talks a little about junior achievement. And as always, any donations that are made in the next 30 days, we'll match them up to $4,000. So we're really excited to partner with Junior Achievement. Tonight's presentation is on estate planning, but we've had a couple questions about the last couple days in the market. I just want to take a minute to kind of put it in perspective, because clearly we're starting to see some more volatility. We expect that that's going to be the case. But the interesting thing is we're just getting back to more of a normal pattern. Historically, if you go back to 1980, the average intra-year drop is about 14% in the market. So what we're seeing is really not out of the norm. The other thing that's interesting, if you look at the orange, that kind of shows where we've been intra-year, and the blue shows where we end up at the end of the year. So in a lot of cases, while the markets are down quite a bit at some point, like in 2009, it's down over 20%, and yet it ended up just over 20. We think that's going to be the case, as we get close to the election. You're going to see more volatility, but it's really nothing out of the norm. And frankly, it doesn't matter. With the portfolios that we manage, they're designed both for the expected and unexpected. If you have questions, just give your advisor a call. If you've been in for a review, this chart's in the back of the portfolio review report that you've received. We're happy to talk about it. So estate planning versus vision planning. Estate planning just means planning for your estate, and your estate's just all your stuff. And there's really three things that we balance when we're looking at estate planning: control, minimizing taxes, and whatever your vision or goals are. And typically you can have 2 out of the 3. So if you want to maintain control, you may not be able to minimize tax as much as otherwise. If you want to minimize taxes, you may have to give up control, etc. Now the nice thing is, with the changes in the estate tax rules, most people aren't going to pay any taxes anyway. The one thing that we do see, and it's important, and I think you'll hear it tonight, is this is a dynamic process. If you've not updated your estate documents in the last 3 to 5 years, you probably need to do so. And it's something you want to do as tax laws change, as your assets change, perhaps as your family changes over time. Right now, the lifetime gift exemption is $11,400,000. So a lot of people worry about gift tax. Unless you're giving away more than $11 million, you don't have to worry about that. Now the other number people think about is that $15,000 number. If you give an individual more than $15,000, you have to file a gift tax return. But you don't have to pay any gift tax until you give more than $11,400,000. So most people, I'm sorry about this cutting in and out. He's working on it. Most people are never going to run into that situation. The other thing is, a lot of people did what were called AB trusts or credit shelter trusts, because when one person died, you lost that exemption for the other one. In 2010, they created something called portability, where you no longer need to do that. If one spouse doesn't use their credit, it's going to go to the other spouse automatically. So if you have some of the older trust documents, they may not be consistent with this. And again, it's one of those things that if your estate plan is written prior to 2010 or 2012, it really may not meet your goals, and you may need to update that. Oops. He's working on it. Lastly, and this was good news, because a lot of people were concerned when the estate tax laws potentially revert back in 2026, that the government would take back all this extra gifting. As of November, they said they're not going to do that. So essentially, the extra gift amount you can give, and I know this is a lot of numbers, but it's in the books on your tables, is about $5.9 million. Prior to the Tax Act, you could give about $5.4 million. Now you can give 11.4. That extra $5 million, the government's not going to take back. So if you make those gifts between now and 2026, then they're going to stand. So a lot of numbers, they're in your books. What we want to do is try to get to questions. We do have a few already, but before we move on, does anybody have any questions they want to ask? Okay, so the first question we got is, what are some of the biggest mistakes that we see people making with estate planning? And Nancy, what do you think?
Thanks, Randy. Of course, if I have to start with an estate planning mistake, probably the biggest mistake someone can make is not having a plan in place at all. Understanding that we can tend to procrastinate with things and we all get busy. If you were to pass away without any kind of an estate plan in place, rest assured that your resident estate would have a plan in place to distribute your assets on your behalf. And a lot of times it may not necessarily be the plan that you had intended for your heirs and your estate. So it's always good to just at least have a plan in place. That being said, another mistake that people make is, all right, we'll try this one. Another mistake people commonly make is thinking that estate planning primarily has to do with death and dying. And certainly wills and trusts are a large component of estate planning, like Randy was saying, from a control perspective. But the other thing you have to keep in mind is what happens to you if you're incapacitated and not able to make decisions on your own behalf. So we always encourage our clients to make sure that their estate plan includes a durable power of attorney, and that's someone who can help take care of your legal and financial matters. Also a healthcare power of attorney, someone who can take care of your ongoing health situations if you're not able to make those decisions for yourself. And then also a living will, which would be your end-of-life choices that you want implemented on your behalf. Those can be all the same people, they can be different people, but you're going to want them to be trusted individuals. You're also going to want them to be aware of the fact that they have this responsibility and make sure that they're able and willing to participate on your behalf with making these decisions. Know that if you don't have a power of attorney, the courts are going to be the ones responsible for making these decisions for you. So again, those are always good documents just to keep in mind. Something else to keep in mind, as Randy mentioned, estate planning is a very fluid process. The general rule of thumb is you want to make sure that once that estate plan is in place, you're reviewing that about once every 3 years. That being said, if something happens from a life perspective, maybe a family member's added through marriage, or you have a child or a grandchild, you have a divorce in your situation, death, even if you change your residence state, those are all situations that would warrant meeting with your estate planning attorney and making sure that your plans and your wishes are still going to be carried out given current law and with the new situation that's occurred, whatever that might be. It's also at that time good to review your fiduciaries, meaning whoever your executor is going to be, whoever you're going to have as a trustee on your trust, making sure that these people are still healthy enough and willing enough to be able to transact on your behalf with whatever those responsibilities might be. And as we talk about reviewing, beneficiaries come to mind. Beneficiaries, that's something we always talk about with you folks when you come in to meet with us. Make sure that everything's current and up to date, and that's a big issue that you want to make sure that you're staying on top of. Beneficiaries allow you to directly transfer assets outside of the probate process. And beneficiaries can be added not only to IRA accounts and 401k accounts or retirement accounts as you would commonly think of, but we have the capability of also adding beneficiaries to individual brokerage accounts, joint accounts, even bank accounts, mortgage deeds. So making sure that you have beneficiaries in place so that those assets can transfer outside of probate and it's a little bit more efficient. We always recommend that you have at least one primary beneficiary and also a contingent beneficiary in place. The contingent beneficiary would take effect in the event that the primary beneficiary were to predecease the owner, or the owner and the primary beneficiary passed away at the same time. So again, just a good planning mechanism to have in place on any of your accounts. And then last but not least is making sure that you have someone who's professionally qualified being able to help you with your estate plan. I know there's a lot of legal websites out there that can walk you through some questionnaires and generate something that may have some personalization to it, but it's going to be fairly boilerplate. There's going to be a lot of legalese and potential confusion involved with the process. So that being said, it's always nice to have, as we've just touched upon briefly here, there's a lot of moving pieces to an estate plan and a lot of legal changes that can happen within the system. It's always nice to have a qualified professional that can ask you the right questions, make sure that your wishes are prioritized and going to be carried out properly at the proper time. The last thing you really want to do is go through the exercise and think that you've got everything covered, and then for whatever reason, because it wasn't done properly, then it's not going to be carried out and your heirs aren't going to be taken care of the way you thought so.
Cool.
Any questions?
Okay.
Thank you.
They are turning on the air conditioning too, so we're working on sound and AC. How many of you guys have email? Yeah, everybody. How many of you store photos online or use Facebook? Most of you. One of the things people don't think about is estate planning for their digital assets. And as with many things, the law is slow to keep up with those types of types of things. But digital assets are now a new category for estate planning. And privacy laws about storing, sentimental things like photos, but also things that have monetary value, like digital currencies, like a Bitcoin or Litecoin or a URL, or believe it or not, even gaming characters. People have sold characters in World of Warcraft for up to $100,000. So the characters can have some value. One of the things is that if you pass away or you're incapacitated, who's going to have access to some of your financial information, like bank accounts, brokerage accounts, PayPal, eBay, those types of things? So one of the things to think about is, do you have a digital executor? And that's something you can name in your papers specifically. The other question you ask yourself is, what do you want to happen or should not happen to those accounts? Who do you want to see your email? Who do you want to see your pictures? Who gets to make those decisions? So it's something to think about. If you have a Facebook page, when you pass away, do you want all that to go away? Or do you want it to become, something like a memorial page? If you're incapacitated, what do you want to happen to that? The other thing is, as I say, there are a lot of other types of things people are storing, ranging from medical records to photos. And again, how do we identify them? It used to be, if you're incapacitated or you passed away, someone went through all your papers and found all this stuff. Or if you were prepared, you had a list. But now if it's on the computer, do you have a list someplace that somebody is aware of? Do you have a list of your passwords so somebody can get into this stuff? And so the default rules with people like Gmail is that it defaults to privacy. So an heir or beneficiary probably cannot get access to your Google Pics, your Google account, YouTube videos, any of that type of stuff. But you can name a digital executor. We've got some information in your books. I'm not going to go through that now, but it's something to think about. Now, state law is very slow in catching up. The first law was in 2014 in Delaware as the first state to put in rules about digital assets. Ohio just signed a law April 6th of 2017. So there's now an amendment to the Ohio Estate Code that specifically looks at digital assets and basically gives fiduciaries the same rights to digital accounts as to tangible property. So again, if you've not updated your estate planning documents or looked at this, it's something to think about. The things we'd recommend is, number one, create a digital inventory. Just list out important usernames, passwords. Don't store them on your computer. Print them or use one of the storage devices, something like LastPass or some of the other programs. Express your wishes on what should happen to this stuff, and then appoint the digital executor. So you may have your brother as your executor, but your 14-year-old niece as your digital executor because your brother doesn't know how to do any of this stuff. Again, things to do, update your documents. As Nancy said, we recommend working with an attorney. We are not attorneys. We can't provide specific legal advice, but we can refer you to an attorney that can work with this. And then there are some services that will assist with this. Google has a cool program called Inactive Account Manager, where basically you can name somebody that gets notified if there's no activity on your account for a given period of time. It could be a week, a month, a year. And basically send an email saying, hey Chris, Randy hasn't logged into his account. Is he dead? What's up? And then if she has the rights to access it, she could. If she doesn't have the rights, she can't access it. She just knows something's happened. Everplans is another program. And then SecureSafe. Secure Safe is another one that you can look at. Switch this one. Thanks. Okay. Now they're all dead. Hang on. See another one? Yep. Which one? Okay. That's working. For now. Nope. Yes. No. Sort of. All right, so there are a lot of services you can use to secure the passwords. Secure Safe, LastPass, and again, there should be some stuff in your information. Any questions on that? Okay. The next question we got was, what are some of the charitable opportunities with estate planning if you want to kind of do good while you're doing well for yourself? So, Dan.
Thanks, Randy. So pursuant to the new tax reform, the Tax Cuts and Jobs Act of 2017, we've all been through, most of us, if we didn't file an extension for 2018, we've been through one tax year under the new reform. So there's a few statistics I wanted to share. There were on average, and this is according to the Tax Policy Center, on average roughly $1,600 in tax savings per household will be effective pursuant to the new law. Prior, the old law, about 5 million people were required to do the alternative minimum tax. That'll be reduced to about 220,000. So there's a significant reduction there. From a charitable standpoint, we do think there are some effects because a lot of people with the increased standard deduction, which was doubled effective in 2018, in order to make a charitable contribution to a charity directly, there was actually an increase. The deduction was capped at 50% of your adjusted gross income. That went up to 60% with the new tax law. And then if you were to donate securities, so stock, mutual funds, exchange traded funds directly to a charity, that remains at 30% capped based on your adjusted gross income. So that remains the same. The difference is, a lot of you, based on your situation with the miscellaneous deductions going away, it may make more sense for you to file the standard deduction going forward. So in that case, direct contributions to a charity are not deductible. And some of you may have experienced that as you filed your taxes for 2018. So one thing to consider, and we have access to this through Raymond James, which is an interesting solution. If you do know, so it would require a little bit of planning ahead, but if you know you're going to make a few charitable contributions each calendar year, perhaps you want to consider lumping them into 1 year. So for example, if you thought you were going to contribute $5,000 to a charitable organization in 2019, $5,000 in 2020, etc., you may want to consider lumping that into one tax year, which could potentially get you above what the standard deduction would be, in addition to the state and local tax deduction, which is capped at $10,000 now. And fortunately, we're not in one of those states like New York, California, where that's really, bad for a lot of taxpayers. But you could lump your contributions into one tax year and create a donor advised fund. So we have access to donor advised funds through Raymond James. There's a $10,000 minimum. If you fund the donor advised fund, you can fund it with stock, mutual funds, bonds, whatever it is, or cash directly. You get an immediate tax deduction up front. The nice thing about that is it's pretty much like your own foundation with not the added expense. There's really low administrative expense. You can invest. There's a menu of investment options based on the objective. So it could be growth, it could be conservative. And the nice thing is you can name the direct charities that you want that to go to either upon death. And you can also make grants throughout your lifetime as well. So that's something that's been a good solution for some folks, especially if there is some planning ahead from a charitable contribution standpoint. Another thing to consider, and this is more relative to those folks that have IRA accounts and are at the point where they're age 70 and a half and they're required to take those minimum distributions each year, you can do what's called a qualified charitable distribution up to $100,000. That's the max per IRA owner. It does not include SEP IRAs, simple IRAs, other retirement plans. There are some stipulations there that they could be, and it can't be ongoing, meaning you can no longer be funding those accounts. But the nice thing, say your required minimum distribution for 2019 is $10,000. So you have to take that money out. You're mandated to take that out, and that's taxable. If you were to take $5,000 of that and directly give that to a charity, that's excluded from your income. So that portion of your required minimum distribution is not taxable. Now the key point is, from a reporting standpoint, it doesn't necessarily show up on your 1099 as not taxable income. So it's really important that you let your CPA or whomever's doing your taxes know that it was a qualified charitable distribution. And we highly recommend writing even QCD next to that on your tax form. So there are a couple different, charitable ideas. The big ones, that qualified charitable distribution. And for those folks where you may consider lumping charitable donations into one tax year, which will get you above that standard deduction, a donor advised fund may make sense. And for the donor advised fund, another thing we see are those folks that have low cost basis securities held outside of a retirement account, where there'd be big capital gains if they were to sell. You could donate some of that highly appreciated security directly to the donor advised fund and receive a deduction immediately. And then one more thing about the donor advised fund is, if you were to pass away, you can elect, similar to an executor or a successor trustee, who makes these decisions on your behalf. So any questions about donor advised funds or qualified charitable distributions? All right.
That's a good thing. Okay. So, how many of you guys have long-term care insurance? Good chunk of you. They say that's the largest unfunded potential liability people have. So one of the questions we got is, what are your thoughts on long-term care asset protection? Maybe get to Kayla.
Thanks, Randy. So, one of the questions that I have for you guys, since it doesn't sound like we're getting a lot right now, is how many of you know somebody that has experienced a long-term healthcare event, whether that's needing to go to assisted living, a nursing home, or even just having someone come and help at home, by show of hands? Yeah, so a lot of people, and this is certainly a topic that impacts a lot of people, a lot of families. And it's also, I think, a topic that's a little bit misunderstood. So, first I want to talk about a couple of facts, and then also some misconceptions that we see and that we hear about when it comes to long-term care. But first, the facts. So, according to the most recent data by longtermcare.gov, if you're 65 years old, there's a 70% chance that at some point in your life you're going to need some form of long-term care. And the cost for that care continues to increase. In the state of Ohio, for assisted living or a home health care aid, you're looking at around $3,000 to $4,000 a month. And that cost increases up to about $8,200 a month for a private room in a skilled nursing facility. And again, those are just the averages. We hear of numbers much higher than that, depending on where you're getting that care. So it's certainly something that's very expensive. But are there any questions on what long-term care is, what long-term care isn't? Yeah.
What's like a duration of time that they consider long-term care?
No. Yeah, so good question. The question is, what is the duration of time that they consider for long-term care? So to answer it in terms of how when we get to long-term care insurance, it's not necessarily based on how long you need it. It's more so a long-term care event is basically going to be something. For most insurance policies, you're going to have to qualify by not being able to do two activities of daily living. And so or ADLs. And so there are 6 activities of daily living in the insurance world. And those are, and hopefully I'll remember them all, bathing, eating, dressing, transferring, continence, and toileting. So if you can't do 2 of those 6, then in most cases you're going to qualify for long-term care coverage. So it's not how long you can't do that for, but that qualifies you for the coverage. But I think to answer your question or maybe a different question is, how long do those events typically last on average? And one of the things that I think is somewhat interesting, I don't know exactly why it is, women actually tend to have a long-term care event that lasts longer than men. So for women, the average long-term care experience is about 3.7 years, and for men it's 2.2 years. And again, that's the average. So, does that answer the question though? Okay. Yeah, and again, with that, it's an average, and some of those events last only a month, and some of them, like Alzheimer's, that's the big one, where physically people are relatively healthy, but they need that round-the-clock care for maybe 5, 10, 15 plus years, and that's where you really run into the issue when it comes to asset protection and what that can do to somebody's finances. Any other questions just generally on what long-term care is, and you want to talk a little bit about how to insure against it potentially? Okay, so go ahead.
I just heard on the radio that a lot of the companies are dropping out of long-term care because it's not profitable for them.
Yeah.
So is that driving everything up in the cost of long-term care?
Yes, in some instances. So that's a great kind of lead in to talk. Let's talk about the insurance. And so really there's 2 main types of long-term care insurance that we're looking at, that we see. There's the traditional long-term care policies that have been around forever and are still around. A traditional policy, think of it similar to car insurance. It's kind of that pay-as-you-go. You're paying that annual premium. If you have a long-term care event, then the insurance is there to pay for it. If nothing happens over the course of the year, insurance company keeps that premium, you move on to the next year, you pay another premium. So that's the traditional market, and that's where you are seeing some of these companies, John Hancock's one of them, that they've gotten out of the market. Now if you have a John Hancock policy, they're still valid and they're still fine. They're just not issuing any new policies. And one of the reasons is that with all the advances in healthcare, people are living a lot longer with these chronic conditions, and it's really caused a problem for these insurance companies because the claims are a lot more than they anticipated when they set those premiums. So yes, you're seeing some companies get out of the market just because it's not profitable. And the other big thing you're seeing with these traditional policies that's becoming a problem is that they're raising the ones that are still in the insurance business are raising those premiums, and I'm talking to the tune of 30 or 40% a year. So unfortunately you can run into a scenario where you took out a policy 10 years ago, you've paid on it for the past 10 years, you're 10 years older, 10 years closer to statistically maybe needing that care, and then you get hit with a 30 or 40% premium increase, and what do? Is that affordable? Can you still afford that? Do you reduce some of those benefits? But that's really the issue with those traditional policies, and a lot of it's just because they were mispriced originally. I would say if you do have one though, it's probably a pretty good deal. You're not going to get anything better in today's market. So that's the traditional side. The other type of insurance is it's called asset-based long-term care. The way that works, just generally speaking, it's not funded with an annual premium per se, but typically it's carving out a portion of your investments. That funds the policy as a lump sum. And what that does is it generates a benefit base. And so that benefit base, the nice thing and what people like about those asset-based policies is that they know that the insurance company is going to pay out a claim one way or another. It's not that use it or lose it. Someone's going to receive a benefit from the policy. So you carve out a portion of your portfolio, put it into an asset-based policy, you receive a benefit base. One of 2 things is going to happen. You're going to receive benefits from the insurance company if you have a long-term care claim, And best case scenario, if nothing happens, you're healthy, when you pass away, that benefit base gets passed on to your beneficiaries as a death benefit. So we are seeing more people consider those asset-based policies for that reason. There's no premiums are guaranteed not to increase, so you avoid that issue, and they know that someone's going to get a payout other than the insurance company. Oh, go ahead. I think the question was, can you use an HSA as for long-term care? Yeah, well, I mean, you can use an HSA for medical expenses, and so theoretically, yes. What I would say is most people aren't going to have enough in their HSA to fund a long-term care event. But yes, you would be able to use the dollars that are in an HSA for those medical expenses. But that also brings up another, one of the other misconceptions that we sometimes hear is that I think there are some people that think that Medicare is going to cover some of these long-term care events, and that really isn't true. The only thing really Medicare is going to cover is the first 100 days in a skilled nursing facility. There's not going to be any coverage for assisted living. There's not going to be any coverage for any sort of home health care. And then once you're beyond those first 100 days, there's no coverage there either. Did that answer your question, though, about the HSA? Okay. Go ahead.
My policy, I think it's a traditional one, has a limit, dollar limit as to how much care they're going to give you over the years.
Right.
I think it's graduated so that you know that you have at least a three-year limit. Because there's a certain amount of dollars in that policy.
Right.
So if that kind of cuts it off, once you get past that up.
Yeah, so depending on the policy, but absolutely, it's common in traditional policies that, and to repeat the question is, the policy that he has some limitations in terms of what the insurance company is going to pay, and that is common in a lot of the traditional markets. There's going to be typically a daily benefit amount, so they will pay a certain dollar amount per day. And then typically there's going to be a benefit period that, depending on the contract and what premium you're paying, maybe it's 3 or 4 years. So the insurance company will pay X dollars a day for this number of years, and right, once that is exceeded, then there are no additional benefits from that policy. You've gotten everything out of it. Yes.
Are you aware of whether or not any of the carriers that write this type of insurance have become insolvent?
No, they're not insolvent. I think maybe another question, or maybe in something that we do here, there is, I think, maybe a perception. I would say it's more of a misperception than what we see in practice, that some of these insurance companies might fight legitimate claims and give you a hard time as far as receiving a payout. We really don't see a lot of that, but in those asset-based policies, one of the things, if you think about it and put yourself in the insurance company's shoes, because as soon as you sign up for that policy, you know that, or the insurance company knows that a benefit is going to be paid. It's either paid to you or it's paid to your beneficiaries. There's not going to be an incentive for them to not pay out a legitimate claim. But to answer the question about insurance companies becoming insolvent, no, that hasn't happened. Yep, a couple back there.
Do veterans get any benefits? Veterans?
Yeah, absolutely. And there are a lot of benefits that are available to veterans, and I think we do a pretty terrible job of making that public. In general, I think some of the feedback that we've gotten from veterans is the Veterans Service Commission's been a really good resource, that if you reach out to them, they can look, because those benefits are actually going to be specific to when you served, was it in wartime or not. But there absolutely are some benefits, and and there's no question it's worth exploring.
What's the name of that office we have? Is it referral? Don't we have this one?
Go ahead.
Can you explain the 5-year rule and how
Yeah.
you protect assets for long-term care?
Yeah, sure. So the 5 years, so the question is, can you explain the 5-year rule, how to protect assets for long-term care? And so what is referred to as the 5-year rule, that's generally speaking, that's the rule if you're trying to qualify for Medicaid, which is different than Medicare. So Medicaid is a needs-based governmental assistance program, and you really have to be insolvent. You have to be at the poverty level to be able to qualify for Medicaid. So the 5-year rule, what that says is that and the reason it's in place is that the government's trying to protect against someone who knows they're going to be in a long-term care situation, or they get a bad diagnosis, giving away all of their assets to their children, qualifying for Medicaid so that the government pays when they had the assets. So the 5-year look back says that once you apply for benefits, the government will look back 5 years prior and look at any sort of gifts or financial transactions, any gifting of money to anybody, and they're going to count that as a countable asset. So what they're going to say is that for you to be able to qualify for Medicaid, you've got to have down to about $2,000. So if you gifted $100,000 to your son or daughter, that money is going to be counted. The government's going to expect you to use those dollars first, which means you better hope that they're still there. And the other thing I would say about Medicaid planning and trying to qualify for Medicaid, I think sometimes people, don't get me wrong, people don't want to pay for long-term care. It's not something that anybody wants to pay for. It's incredibly expensive and it's not fun. But I think it's really important to understand what qualifying for Medicaid really is and what that gets you in terms of the quality of care that might be available. When you have a long-term care policy, or you can self-fund, I mentioned that we're looking at anywhere from $3,000 to $8,000 a month for care. It's expensive, I get it, but you're going to get a pretty good quality of care, and you are in the driver's seat. You can choose which facility you want to go to. When you're on Medicaid, your choices are very, very limited. You're probably going to have a roommate. The facility that you're at might not be the best. So I would caution people to really understand what you're signing up for when you try to qualify for Medicaid. But that's the 5-year rule. Any other questions? All right.
Cool. Thanks, Gail. 2 other things real quick with the asset-based policy. If you pay for a rider, it'll pay forever. The benefits will be paid until you die. So you can't outlive it. And the other thing is, when you die, the benefit to your heirs is tax-free because it's considered a life insurance policy. So it's kind of a neat thing. Okay, any other questions before we jump to another one we were given? This is actually a great question. And the question was, what should I be thinking about when naming beneficiaries? And how should I communicate that to my family? How should I tell them who I've named as beneficiaries? So, Nick?
Thanks, Randy. I'm just hoping that the mic doesn't cut out for this part of the presentation. But, this is a question we get a lot of times from clients when we're communicating with them and meeting with them is, what I want you to walk out of here today is ask yourself this question. If you came with somebody that you love today, what would happen if something happened to you, right? So that's the toughest question to want to think about because nobody wants to think that we're not around anymore and what would happen to our surviving spouse, significant other, or certainly our kids. But I can give you an example. A couple years ago, my brother and I sat down with my father and we just asked him this question. We said, what do you want to have happen to you if you need assisted living or you need extra help with your health? Or what do you want to have happen with your money? And what I can tell you we observe in our meetings is there's a difference in generations, right? So if you're born in the early 1900s and or may have known anybody that lived through that Depression period, they're generally more closed off, right? They don't really communicate what they have, what they want to have happen. And then you flash forward to today's millennial generation, and they basically are posting everything that they eat, to what they have, to what they want to do, and literally every micro thought they have online for everybody to see. So I think it's simple. You ask a general question, but if you look around the room tonight, there's a lot of couples here. And I'd pose the question to you. If you are the person in your family that manages the finances, does the other person with you understand their choices and or what would happen if something happened to you? So it starts with that conversation. And when we meet with people, a lot of times the largest asset they have is a retirement account of some sort. So like an IRA or their house, right? So we know that if you're married and you have your IRA, your spouse is probably your primary beneficiary, and you may have your kids listed as contingent beneficiary. So again, it's just the question is, well, what do I want to have happen with my money? And in most cases, you're going to know what your spouse is going to do with that money, right? Maybe. No. So we have lots of thoughts that come out during the meetings, I can tell you that much. So, but it's not your problem anymore, right? The next layer down, though, the kids, is now this is a conversation that is a little bit more in depth, because most people may have 2, 3, 4 children, and what we hear is they're all different. There may be one happily married and financially sound, all the way to the other one that's still living at home at the age of 40. So what happens with that money, your IRA, if something happens to both you and your spouse? Okay? So the one other thing I'd say to you is, a lot of times as people get older, to simplify the reporting is start rounding up things and getting them in one location. It certainly makes things a lot easier, like Nancy was talking about, assigning beneficiaries to your assets, right? But we came across the scenario the other day. A client's great aunt is 95 years old, and our client helps take care of their great aunt at this point. And they found out that she had stock certificates originally purchased 60 years ago in a cardboard box down in the basement. And then they asked her, well, what else do you have? And she frankly didn't know. You know, she just never paid attention to it. She receives dividend checks in the mail, and that's how life goes on. So that individual was not open to, consolidating things, because they were of that era where they saw multiple banks fail. So there's money all over. But what I can say is, ask yourself this question: do you want to make it difficult or easy for those that you leave behind? Right? And that's what estate planning is. So you can certainly plan in advance and make things a lot easier for those that you love or leave behind. Or you can start visiting every random bank in Northeast Ohio and find out if there's money, right? So it'd be like a treasure hunt. But my goal today was, when we get this question, I really actually ask a question back. Because we can't answer, who do you assign the beneficiary? Or, and frankly, you can't say, what are they going to do with the money? But you can certainly have that conversation and make sure you're both on the same page. So, any questions? Yes?
It's not to do with that, but I was just curious, do you recommend putting your car titles in that and joint survivor and doing?
Yeah, I mean, so generally when the question comes in with estate planning, the first response is you need to coordinate with your estate planning attorney, because adding a TOD is what it's called, a transfer on death, to a title of a car certainly would help bypass probate, right? Probate's not the worst thing in the world. It just kind of delays the division of assets if something happens to you. I can personally attest, my mother passed away 8 years ago, and her motorcycle had a TOD on it. I walked into the DMV, gave them the title and the death certificate, and it was transferred, right? The one thing we do hear from estate planning attorneys, though, is imagine owning a home and then having 5 children, or owning a car and having 5 children. and adding those 5 children as beneficiaries of that asset. So imagine the complications that happen after a death, and certainly all the siblings probably don't get along perfectly. If one of those individuals don't want to sell the asset, they hold up the whole show. Okay. So the feedback we get from estate planning attorneys that we work with is probably keep it as simple as possible, maybe pass it through your will, unless you know you want to designate that asset to one specific person. In the case of a car, probably pretty simple. In the case of a house, yeah, I mean, that's quite a bit more money in most cases. So, does that answer your question?
Yes.
Okay. Any other questions? Good. Oh, sir.
Real quick, is it better, in your opinion, on a death transfer cash, or move your cash back into assets and transfer the assets to the beneficiary? Is there a tax benefit or a management benefit?
Yeah, so the question is, does it make sense to transfer assets to a beneficiary in cash, or transfer the assets in kind as the investments stand as they are today? And I'd say it depends on the type of account. A retirement account, you're going to have a couple different options. Like I was saying before, if your spouse is the beneficiary, they can inherit the IRA as their own. If it's a non-spouse beneficiary, they get something what's called a beneficiary IRA. So in most cases, we transfer assets in kind, and then we would work with the individual surviving spouse or the children to decide what specifically is needed for them. In the case of after-tax accounts, so if you have a trust account or a joint account, in most cases, you're going to get a step up in cost basis on those investments to the value on the date of death. And again, then it's working with each beneficiary to decide what they want to do. We've had cases both ways. 2 weeks ago, we cashed out a complete trust because the beneficiaries wanted to take the cash and pay off debt or buy a home. Last year we had an example, 3 children, each wanted to take the assets in kind because there were some gains on the investments after the step up in cost basis, and they didn't want to pay the tax on the gains. Okay. So, answer your question? Yeah. Any other questions? So the most important thing I can express is it's really important to work with an estate planning attorney to really dial everything in, because all the pieces do need to work together. Okay? That's it.
Thanks. Yeah, one of the things, and Nancy touched on this, make sure your beneficiaries are up to date and they reflect who you think they are. When I first started, I had a client in a second marriage, and he passed away unexpectedly with a life insurance policy, and his wife came in. Turned out he had never updated the beneficiary. His ex-wife got all the money, and there's nothing you can do about it. So make sure your beneficiaries are up to date. The other thing Nancy mentioned that I think is so important is having current powers of attorney and medical powers of attorney for each other. And again, find what's feeding back. Try over here. Keep going. Ah, there you go. No, I'm not going anywhere. So, making sure that the beneficiaries are what you think they are, making sure your powers of attorney are in place. Keep in mind, a power of attorney doesn't work once you pass away. Some people think they can do things with that, but you can't. The other thing that Dan touched on kind of falls in place with what Nick's talking about. If you don't have children and you do want to create a lasting legacy, or even if you do, you can name a donor advised fund as a beneficiary on an IRA. And those assets can basically be doled out forever and create a legacy permanently for you. So, something to think about. But those are the types of things, again, working with your attorney, and I do think it's important you work with an attorney, not the legal Zoom do it yourself, because that generally doesn't turn out very well. It's not your problem because you're dead, but somebody has to deal with it. Any other questions kind of on the estate planning stuff? No other questions. The other thing we'd encourage is a family meeting. And we're seeing a lot of these where if you have someone named as your power of attorney, let them know what you have. if you want to come in the office and meet with your advisor, we can go through the types of accounts without necessarily disclosing the values. So they understand if you become incapacitated, hey, I've got this, I've got that, here's who I talk to. You know, I meet with Nancy or I meet with Dan. Here's who I talk with, those types of things. And that can be very helpful as well. If you'd like to do that, just let us know and we can facilitate that. Any other questions before we kind of wrap up? Nope. We do have a lot of cool stuff coming up this summer. You guys are going to get some notices. The appreciation event is going to be in August. We're doing the baseball game again. We are just about sold out on next year's trip, which is the Ritz-Carlton Yachting Experience. And then on September 17th, we have something that I think is going to be really, really special. How many of you guys saw the movie The Pursuit of Happiness with Will Smith? Okay, pretty cool movie. So that movie was Will Smith, actually his child was in it. That movie's about a guy named Chris Gardner. We have Chris Gardner coming, and he'll be speaking at the Mentor Performing Arts Center. We can accommodate 1,000 people, which I think will sell out. So if you're interested, we're telling you guys ahead of time, call the office, sign up, and you'll see an invitation shortly. If you do think of questions, give any of us a call. That's why we have a team. Again, the entire team is outlined on your tables, and we appreciate your coming out this evening. Thank you.